Modes of discovery under Section 10, Rule 116. This rule refers to the right of the accused to move for production or inspection of material evidence in the possession of the prosecution. So it means to say it authorizes the defense to inspect, copy, or photograph any evidence of the prosecution in its possession after obtaining the permission of the court. So it means to say the defense counsel, the accused may inspect, photograph any evidence of the prosecution in its possession, provided there is permission granted by the court. To grant the motion for production and inspection of evidence, the motion must show good reasons with notice to all parties under Cruz Jr. versus People. So the intent to inspect, copy, and photograph must have the intention of good reasons, with good reasons, and notify all parties. What if the prosecutors fail to comply with the production or inspection? Rule 116 is silent on the consequences of refusal by the prosecution to produce the evidence or documents subject of discovery. So, therefore, we can apply Rule 29 of the Civil Procedure, wherein the refusal to comply with the modes of discovery, and Paragraph E, Section 3, Rule 131, that when evidence is suppressed, it is presumed adverse to the prosecution. So when there is production of evidence, such production is unfavorable to the prosecution. That is under disputable presumption. What are the grounds to suspend the arraignment? First is that the accused appears to be suffering from an unsound mental condition, which effectively renders him unable to fully understand the charge against him and to plead intelligently thereto. In such case, the court shall order his mental examination and, if necessary, his confinement for such purpose. So again, the very first ground to suspend the arraignment, if there is the manifestation of unsound mental condition that renders him unable to fully understand the charge against him and to plead intelligently. Therefore, the court will order the confinement of the accused and undergone a mental examination. And the next ground to suspend arraignment is the presence of prejudicial question. Again, there will be a prejudicial question if there is institution of civil action prior to the criminal action, and the issue or resolution of the civil action is a determinative of guilt or innocence of the accused in the criminal action. So therefore, suspend the civil action in the presence of prejudicial question. So at the same time, suspend the arraignment. Thus, the pendency of petition for review before Secretary of Justice suspend the arraignment. If there is a pending petition for review before DOJ, the court in its discretion may suspend the proceeding upon motion by the parties. However, the court should not set the arraignment of the accused and direct the DOJ to submit the resolution disposing of the petition on or before the period fixed by the rules, which in no instance could be more than 60 days from filing of the petition for review before the DOJ. Otherwise, the court will proceed with the arraignment as scheduled and without further delay. Again, if there is a pending petition for review before the Secretary of Justice, any parties may file a motion to suspend the arraignment on the ground that there is pending or petition for review before the Secretary of Justice. However, the grant of motion depends upon the discretionary of the court. If there is grant of the motion to suspend, court shall direct the DOJ to submit the resolution disposing, making decision of the petition on or before the period fixed by the rules, in which it could not be more than 60 days from filing of the petition for review before the DOJ. So, once there is pending petition for review before Secretary of Justice, the court shall direct them to make decision on the petition within 60 days from filing of such petition to their office. After the expiration of 60 days, the court shall schedule the arraignment without further any delay. That is in Aguinaldo versus Ventus. Bill of Particulars. Person's constitutional right to be informed of the nature and cause of accusation filed against him signifies that an accused should be given the necessary data on why he is subject of the criminal proceedings. It must be described with sufficient particularity to enable the accused to defend himself properly. That is from People versus Honorable Mencius. So again, that is very important that accused should be given necessary data on why he is subject to the criminal proceedings. And such data must have the sufficient particularity to enable the accused to defend himself properly. Motion for Bill of Particulars. This is the rule. Section 9, Rule 116. The accused may, before arraignment, move for a Bill of Particulars to enable him properly to plead and to prepare for trial. The motion shall specify the alleged defects of the complaint or information and the details desired. Again, the motion for Bill of Particulars must be filed before arraignment. And the motion shall specify the alleged defects of the complaint or information and the details desired. But practical move, if the information does not properly state the crime, then the proper move by the accused is to file motion to quash the information for failure to charge an offense. When is Bill of Particulars available? When the information, though sufficiently charges an offense, if insufficient to give accused sufficient details of the alleged offenses. For short, there is obscurity in the complaint or in the information, there is ambiguity, so file this Bill of Particulars. It seeks particularization in the information to enable the accused to properly be informed of the charge against him and enable to prepare his defense. The particularity must be such that persons of ordinary intelligence may immediately know what the information means. Romualdez versus Sandigan Bayan. So again, the aim of the Bill of Particulars is to make a simplification wherein an ordinary intelligence may immediately know or knew what the information means. Information for plunder against Senator Enrile. The information states, among others, by repeatedly receiving from Napoles during in or after project identification to the appropriate government agencies of Napoles non-government organizations. Repeatedly receiving. Supreme Court said it is insufficient to merely allege that a set of acts had been repeatedly done and aver that these acts resulted in the accumulation of 172,834,500 pesos as in this case. The information should reflect with particularity the predicate acts that underlie the crime of plunder based on the enumeration in paragraph D, section 1 of RA 7080. You need to establish the predicate acts because the heart of plunder law lies in the phrase combination or series of overt or criminal acts. Again, plunder law lies in the phrase combination or series of overt or criminal acts. Hence, even if the accumulated ill-gotten wealth amounts to at least 50 million, a person cannot be prosecuted for the crime of plunder if this resulted from single criminal act only. Considering that without a number of overt act or criminal acts, there can be no crime of plunder. So it is very important that there is a combination of series of overt or criminal acts. Otherwise, if it is only a single criminal act only, therefore, there can be no plunder. The various overt acts that constitute the combination and series the information alleged are material facts that should not only be alleged but must be stated with sufficient definiteness so that the accused would know what he is specifically charged of and why he stands charged so that he could properly defend himself against the charge. Again, for the crime of plunder, the information should make a particularity in the combination of or series of overt act or criminal acts. So therefore, there should be series of overt acts in committing plunder. Motion to quash under Rule 117. When will you file this motion? When this motion available? The accused may move to quash the complaint or information at any time before entering his plea. The grounds raised for motion to quash can be waived or cannot be waived. This is the rule on waivability. If the accused did not question the defective information at any time before entering his plea, he is deemed to have waived any of the waivable defects in the information, including the supposed lack of particularity in the description of the attendant circumstances under People v. Solar. Again, if the accused failed to question the defective in the information before entering his plea, he is deemed waived. He cannot anymore question it after arraignment. These are the grounds that you will be used if you will file motion to quash the information or complaint. First, that the facts charged do not constitute an offense. That the court trying the case has no jurisdiction over the offense charge. That the court trying the case has no jurisdiction over the person of the accused. That the officer who filed the information had no authority to do so. That it does not conform substantially to the prescribed form. The information does not prescribe to the substantially prescribed form. That more than one offense is charged except when a single punishment for various offenses is prescribed by law. Next, that the crime or the criminal liability or action has been extinguished. That the information or complaint contains averments which, if true, would constitute a legal excuse or jurisdiction. The last ground is that the accused has been previously convicted or acquitted of the offense charge, or that the case against him was dismissed or otherwise without this expressed. And that is already Jeopardy. This time, let us go to each ground and determine if they are waivable or not. First, that the facts charged do not constitute an offense. This is not waivable. Only the facts alleged in the information shall be considered. The court may order or may consider amendment of the information. Example, accused was criminally charged for carrying a loaded firearm without the required written authorization from the COMELEC during election period. He filed a motion to quash, attaching in his motion a certificate of authorization from COMELEC. Accused motion to quash has been denied because it was held that it was not one of the grounds of motion to quash an information. Said attachment is an evidentiary matter, that is in Los Baños versus Pedro. Again, attaching the written authorization for carrying a loaded firearm is not a ground to quash an information. Next, accused was indicted for bigamy. All the elements for bigamy was alleged in the information. Accused filed a motion to quash contending that his previous marriage with his first wife is already annulled. The motion to quash is denied. Again, contending that the previous marriage with his first wife is already annulled is not a ground as provided in the Section 3 of Rule 117. Only those grounds set by the rule can be raised in the motion to quash. Next ground, that the court trying the case has no jurisdiction over the offense charge. It is not waivable. It must be based on the allegation in the information. It must be based in law. It is subject to refiling to the court of proper jurisdiction. Again, jurisdiction is based on the allegation in the information. And also, jurisdiction is based in law. It is conferred by the law. If there is wrong filing of the case, it should be filed in the court of proper jurisdiction. Next ground is that the court trying the case has no jurisdiction over the person of the accused. This time, this ground is waivable. Why? When there is illegality of arrest. Subject to waiver when the accused enters plea. The waiver does not extend to the evidence obtained as a result of illegal arrest. Again, there can be no jurisdiction if there is illegality of arrest. Take note that jurisdiction over the person of the accused is acquired upon his arrest. The arrest must be valid with warrant or voluntary appearance. People versus Umbero. When the accused asks an affirmative relief from the court, there is voluntary appearance, so therefore the court acquires jurisdiction over the person of the accused. Next, when the accused specifically questions the jurisdiction of the court over his person, like motion to quash, warrant of arrest, it is not considered voluntary appearance as long as he have not yet entered his plea. People versus Go. Questioning the jurisdiction of the court over his person is not presumed voluntary appearance until he will enter his plea. Next ground is that the officer who filed the information had no authority to do so. This is waivable. The rule provides that no complaint or information may be filed or dismissed by an investigating prosecutor without prior written authority or approval of the provincial or city prosecutor or ombudsman. This requirement is mandatory in Kisay versus People. Remember that this ruling was already abandoned by Villa Gomez case. It is not mandatory at all. It can be waived. Thus, if an information has no written approval of the chief prosecutor or provincial prosecutor, and you as the counsel to the accused does not question it in a motion to quash, you waive it by your silence, acquiescence, or failure to raise such ground during arraignment or before entering plea. For short, the failure to raise the absence of approval of the provincial or city prosecutor or ombudsman does not affect the case or information filed in court. The next ground is that the information or complaint does not conform substantially to the prescribed form. According to Section 6, Rule 110, sufficiency of complaint or information if it states the name of the accused, the designation of the offense given by the statute, the acts or omissions complained of as constituting the offense, the name of the offended party, the approximate date of the commission of the offense, and the place where the offense was committed. Important note, wherein from People versus Mendoza, treachery is not alleged in the information, but it was proven in evidence during trial that there is treachery. The opposing party or defense counsel did not object to the introduction of evidence. Can the court consider evidence of treachery in its decision? That's a big no. Otherwise, the court will violate the constitutional right of the accused, the right to be informed of the nature and cause of accusation against him. So, even though qualifying and aggravating circumstances are proven during trial but they are not alleged in the information, the court cannot consider circumstances in deciding the case. In People versus Valdez, commission of crime is attended by treachery. That is the phrase in the information. It is merely alleging the qualifying circumstance attended by treachery. Treachery is not allegation of facts, but it is a conclusion of law. Treachery must be alleged with specific facts constituting circumstances. The information must be an allegation of fact, but not conclusions of law. Next ground is that the information or complaint allege more than one offense, except when a single punishment for various offenses is prescribed by law. This is waivable. The accused may be convicted for as many offenses charged in the information as are proved during the trial. Next is the criminal law action or liability has been extinguished. Under Article 89 of the Revised Penal Code, absolute extinguishment when there is death, service of sentence, amnesty, absolute pardon, prescription of penalty, marriage of offended women, and in Article 94 Revised Penal Code, partial extinguishment when there is conditional pardon, commutation of sentence, allowance for good conduct. Then this ground is not waivable. The next one is double jeopardy. It is not waivable. What are the requisites for double jeopardy? The very first is that there is a valid complaint or information filed in court, and such was filed in competent court. It means to say the court has the jurisdiction over the case. Then a valid plea was entered by the accused, whether plea of guilty or not of guilty. The next one is that acquittal or conviction of the accused or the dismissal or termination of the case against him without his express consent. So these are the requisites to constitute double jeopardy. Take note in the fourth requisite in double jeopardy, dismissal should be without accused express consent. Otherwise, if there is express consent given by the accused, there can be no double jeopardy, except if the accused moves with consent, but double jeopardy will take place in the mirror to evidence, dismissal due to speedy trial, and discharge as a state witness. Here, even there is the consent of the accused in the dismissal, but still double jeopardy will apply in the mirror to evidence, dismissal due to speedy trial, and discharge as state witness. These are the different kinds of dismissal, and let's determine whether or not double jeopardy will apply. In provisional dismissal, there can be no double jeopardy because case can be revived in a period according to rules. While in dismissal for insufficiency of evidence, double jeopardy will apply. Dismissal for violation of speedy trial, there can be double jeopardy. In case of withdrawal of information filed in court, if withdrawn before arraignment, there can be no double jeopardy. If withdrawn after arraignment and withdrawn over the objection of the accused, there can be double jeopardy because the withdrawal over the objection of the accused tantamount to acquittal. The effect if the elements of double jeopardy are present, the accused may not be prosecuted anew for the original offense charge or for any attempt to commit the same or frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charge in the original complaint or information. That is under Section 7 of Rule 117. So those facts and circumstances alleged in the original complaint or information which was subsequently dismissed cannot anymore be alleged in the new information or complaint filed against the same accused. Interesting case, Aguilar versus Judge San Pedro. The accused was convicted for reckless imprudence resulting in slight physical injuries. Now, he is being charged with reckless imprudence resulting in homicide and damage to property. Both cases arose from the same incident. The Supreme Court ruled that reckless imprudence is a single crime. Its consequences on persons and property are material only to determine penalty. Therefore, prior conviction or acquittal of reckless imprudence bars subsequent prosecution for the same quasi-offense. In this case, there are two reckless imprudence was filed against him, but this case arose from the same incident despite different grounds alleged therein. Since there is already conviction for the first reckless imprudence, the decision bars already the second reckless imprudence because double jeopardy shall apply already. In these following cases, there can be no double jeopardy. First, the graver offense developed due to supervening facts arising from the same act or omission constituting the former charge. The facts constituting the graver charge become known or were discovered only after plea was entered in the former complaint, and the plea of guilty to lesser offense was made without the consent of the prosecutor and of the offended party, except as provided in paragraph F, section 1 of the Rule 116. Take note that in provisional dismissal, there can be no double jeopardy because the case can be revived in a period as according to the rules. In Section 8, Rule 117, a case shall not be provisionally dismissed except with the express consent of the accused and with notice to the offended party. The provisional dismissal of offenses punishable by imprisonment not exceeding 6 years or a fine of any amount or both shall become permanent 1 year after issuance of the order without the case having been revived. With respect to offenses punishable by imprisonment of more than 6 years, their provisional dismissal shall become permanent 2 years after issuance of the order without the case having been revived. The requisites for our provisional dismissal be made. It is when the prosecution, with the express conformity of the accused, and the accused moves for a provisional dismissal of his case, or both the prosecution and the accused move for its provisional dismissal. The second is that the offended party is notified of the motion for provisional dismissal of the case, and the court issues an order granting the motion and dismissing the case provisionally. And the public prosecutor is served with a copy of the order of provisional dismissal of the case. That is in Bonsubre versus Hierro. Where do we compute the 1 or 2 period for reviving the case as criminal case? It shall be reckoned from the issuance of the order of dismissal. However, Supreme Court said that this order shall only be permanent after the service of the order of dismissal on the prosecutor who has control of the prosecution. The prosecutor cannot be expected to comply with the timeline unless he is served with a copy of the order of dismissal. Co versus New Prosperity Plastic.